Good morning to all my dear students. Today we are going to continue with the last topic dealt by me, that is on appearance of party and also about non-appearance of the parties, meaning thereby the consequences of non-appearance. In my last lecture, I had discussed about the rules pertaining to appearance of parties under Rule 1 and 12. And secondly, we have dealt with what would be its consequence on the suit where neither party appears, and thereafter we have also dealt with a situation wherein only the plaintiff appears, and in this regard the law laid down is the law is laid down under rules 6 and 10 of order 9 CPC. Further, we have discussed about what would be the consequence where only defendant appears and plaintiff does not appear. The relevant rules pertaining to this are given under rule 7 to 11. And in the end of my last lecture, I had discussed about that where summons has not been served on the defendant, what would be its consequence to the civil suit, and the relevant rules pertaining to the law laid down in the said subtopic are given under rule 2 and subrule 5 of order 9 CPC. Now we are going to start with the new topic under new subtopic under the topic of appearance and non-appearance of parties, and that topic subtopic is ex parte decree. What do you mean by an ex parte decree? The word or the expression ex parte decree has not been defined in Code of Civil Procedure. As you all are aware that various expressions or words have been defined under section 2 of the Code of Civil Procedure, and therein the word decree has been defined, but the legislature deliberately left the left to define the word or the expression ex parte decree. The relevant provisions pertaining to ex parte decree has been given under Order 9, Rule 13 and 14 of CPC 1908. Furthermore, we have to explain the expression ex parte decree. As I had already apprised you, the said expression has not been defined, but by way of judicial jurisprudence or by way of judicial interpretation given by various jurists or judges, it can be defined as It is a decree which was passed by the court in the absence of the defendant. So, this is the decree which has been passed in the absence of the defendant in the civil suit, where the plaintiff appears and the defendant does not appear when the suit is called out for hearing, and if the defendant is duly served, the court may hear the suit ex parte and pass a decree against him. Now, if a decree has been passed, what would be its validity? This is a very important question to be understood by a law student. Such a decree is neither null and void nor inoperative, but the said decree is merely voidable, and unless and until it is annulled, remains valid. Furthermore, it is a valid, legal, valid, operative, and enforceable like a bi-party decree, and it has all the force of a valid decree. So, from this, we may infer that this is the similarity between a decree in which both the parties appear and an ex parte decree. The similarity is that both decree tantamounts to be a final decree and a valid decree in the eye of law. Next, what if could be done if an ex parte decree was passed against the defendant, meaning thereby what are the remedies available to the defendant in case an ex parte decree has been passed against him. There are four remedies provided under the law. The first remedy is to apply to the court, meaning thereby the same court by which the decree has been passed, to apply to the court by which such decree is passed to set it aside, and this is given or contemplated under Order 9 Rule 13 CPC. Next remedy is to prefer an appeal against such decree. Third, to apply for review. And the last one, to file a suit on the ground of fraud. So these are the four remedies which are available to the defendant. The above remedies are concurrent in nature. Furthermore, how the decree can be set aside under Rule 13. In this, the defendant has to file an application stating the sufficient reasons for his non-appearance on the last date of hearing, whereby an ex parte decree has been pronounced by the court of law against him in the civil suit filed by the plaintiff. So this remedy is available to the defendant. Now, by whom this application needs to be filed? Whether the plaintiff can also file? Answer is no. The plaintiff cannot file an application under Order 9 Rule 13 because he is not an aggrieved party. That application needs to be filed only by the defendant. And here there is a distinction between an application and an appeal. In appeal, both parties have the right, or both parties may approach for remedy in case aggrieved from any order pronounced by the court. But under Order 9, Rule 13, CPC, it is only the defendant who has this power, or who has this remedy given under the law. Next, what are the grounds needs to be stated in setting aside ex parte decree? The grounds, the following grounds may be taken in the application for setting aside the ex parte decree. The first ground was that the summons was not duly served as provided in Rule 6. The suit may proceed ex parte against the defendant only when it is proved by the plaintiff to the satisfaction of the court that the defendant did not appear even though the summons was duly served. In that case, an ex parte decree may be passed against him. Therefore, if the defendant satisfies the court that the summons was not duly served upon him, the court must set aside the ex parte decree passed against him. So this is the remedy. He has to show that he has not been served, duly served with the summons. But this would not be applicable in case there is an irregular service of someone. So this is an exception to this rule. Next, the next ground is that he was prevented by any sufficient cause from appearing when the suit was called out for hearing. The court will set aside the decree against him and appoint a day for proceeding with the suit. So from this, we may infer that on being shown the sufficient cause in the application, the court may set aside the decree passed against him and also fix a date in the suit and thereby calls him upon him to appear on the next date and fix the matter on the topic or on the given circumstance which was fixed on the last date. Now, what are the reasons which may be contemplated as sufficient cause? The first and the foremost reason herein is that there was a bona fide mistake as to the date of hearing. If the party or the defendant commits a mistake, commits the mistake, bona fide mistake as to the noting of the date of hearing, the court may treat that it be a sufficient cause for setting aside the ex parte decree. Second ground is, or second possibility to be shown as sufficient cause is sickness of the counsel or the party. If the party himself is sick or the counsel is also sick, then the court may consider such ground to be a sufficient cause. If there is any death of the relative of the party, then that is also a sufficient cause on the basis of which the court may set aside an ex parte decree. So these are some of the grounds on the basis of which the court may set aside the ex parte decree. Now the very next question which needs to be understood by a law student and which is very important from the point of view of the examination is that, is there any limitation period for filing this application? Yes, this application needs to be filed within 30 days from the date of the decree. So from this, we must infer that 30 days is time limit, and this 30 days needs to be computed from the date of the decree passed by the court in the civil suit filed by the plaintiff. Furthermore, whether any notice needs to be given to the opposite side before setting aside ex parte decree. As per Order 9, Rule 14 CPC, it is the duty of the court that before setting aside an ex parte decree, the notice must be given to the plaintiff, meaning thereby an ex parte decree cannot be set aside without issuing notice to the opposite party and without giving him an opportunity of being heard. As you all are aware that this appearance and non-appearance is only for the sole purpose of giving an opportunity of being heard, which is one of the principles of natural justice, that is, odi alteram partem, mentioned under the administrative law. So, from this, we may infer that there is an interconnection between admin law and code of civil procedure. Now, we will move further. Whether, while allowing the application, the court may impose the condition. Answer is yes. The court has very wide discretion in imposing such terms on the defendants as it thinks fit before setting aside the ex parte decree. Next, whether inherent power can be used to set aside ex parte decree. Answer is no. Since the code makes specific provision for setting aside ex parte decree, no inherent powers can be exercised to set aside such decree. Now, what would be its effect if the court set aside the ex parte decree? The consequence would be on the suit is that the suit is restored and the court should proceed to decide the suit as it stood before the decree, meaning thereby the suit is restored and the court should proceed to decide the civil suit as it stood before the decree. Next, whether an appeal can also lie against the ex parte decree. An application of ex parte decree does not lie. Meaning thereby, in case where the appeal has been filed and the same is dismissed, whether an application of ex parte decree can also file again. Answer is no, because to it will tantamount to challenge the order of higher court before the lower court. Is there any exception? Answer is yes. When there is a withdrawal of appeal by the defendant itself, so the appeal has not been decided on merits, as such, an application may lie, and the same would not be barred by Order 2 Rule 2 and Section 11 of this Code of Civil Procedure. Next, whether an appeal can lie against an order rejecting an application to set aside decree. Answer is yes. Appeal can also lie against that. Next, whether revision may also lie. Answer is yes. An order setting aside an ex parte decree is a case decided within the meaning of Section 115 of the Code of Civil Procedure and is therefore revisable. Next, whether review may also file against this against the order whereby this application has been dismissed. Answer is yes. Since all the remedies against the ex parte decree are concurrent, an aggrieved party can also file an application for review if the conditions laid down under Order 47 Rule 1 are satisfied. Now the last question, whether a suit can also be filed against setting aside of ex parte decree. Generally, the answer is no. A suit to set aside an ex parte decree is not maintainable. But if the said decree has been obtained by fraud, then the defendant can file a regular suit to set aside such decree in the court of law. So, from this, we may infer that a suit may not be filed, but if the decree has been obtained by fraud, then the suit may lie. Hope you all have enjoyed this lecture and also have learned from it. Before parting with the today's lecture, I would like you I would like to apprise you with my new topic which I am going to take in my next lecture. And in my next lecture, I would like to discuss with you about interim orders given under Order 39 Rule 1 and 2 and also various other provisions of the code. Hope you all have a great day ahead. Thank you very much. We'll meet you soon in my next lecture.